The Honorable, the Supreme Court.
Thank you very much, folks. Please be seated. And when you're ready, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Jennifer Knapp versus Timothy Dasler, case number 24 AP 059. Appellant Timothy Dasler is self-represented. Appellee filed a brief or requested oral argument.
Okay, thank you. Mr. Dasler, come on up to the podium, please. And you understand you've got 15 minutes and we'll give you a light when your time is close to expiring. So if you would, for the record, please start by introducing yourself and then you can proceed.
I'm Timothy Dasler, defendant pro se. Let's see. So first I want to clarify that I realize that there's another aspect of this case that we've already been through and that's decided. And referring to that, I'm not seeking to relitigate any of that, but that there's a distinct difference between the issuance of attorney fees and prospective pre-filing restrictions as it pertains to a statute where conduct is both on, predating the statute and antedating it. So I just want to make sure that's understood so it doesn't sound like I'm trying to,
Appreciate that. Thank you.
Let's see. Among the issues that I think is distinct is the court found that when the lower court used section 1183 to satisfy 1181, I want to point out a key distinction. In section 1183, it notes that if there is substantially similar issues in a filing, it opens the door to a request to hearing, whereas section 1183 is the definitions. And so under section 1183, where the lower court specifically had said to satisfy section 1183, I think it was section C through D, something of that nature, it turned to section 1183. And what it essentially skipped over is a requirement that in 1183, the filing be lacking in legal merit, factual merit, or relitigating something that was decided in favor of the person requesting the restriction. And in 1183, it creates a presumption of abuse if there are substantially similar filings. And the reason that matters is what you're considering to be the wrong is significant for an award of attorney fees, because that is backward looking as opposed to a pre-filing restriction being forward looking. So I think the distinction matters where when we look at what was the wrong that justified her request, if that wrong is entirely actions that predate the statute, then a financial penalty is a new liability that postdates the statute. Where the conduct predates the statute, her request postdates the statute, it's still the conduct that matters. And so in this case, if we look at the filings that existed after the statute, we had my request for a motion to enforce production of Exhibit 13, and then a motion for summary judgment on that issue to avoid the hearing because there was no issue in dispute, and a motion for contempt on the same issue, which was refiled because there was some problem with the payment processing for the motion for contempt, so it got refiled. So it wasn't duplicative for any reason other than a procedural issue. And the motion for an order restricting abusive litigation was filed in response to those three pending issues. The hearing on the enforcement issue, I prevailed in that hearing. The court had not ruled on the motion for summary judgment, but there really was no issue in dispute. I prevailed, and the contempt issue was based on that same violation. So it cannot be that the contempt issue was so lacking in foundation that it would justify some sort of penalty. And so if we look at that as the basis for her motion, and that she is awarded attorney fees on that motion, I think what is necessary is to look at, if none of those things justified her motion, then an award of attorney fees on that motion is only appropriate if it's considered that it is not retroactive to look back and say, well, there were filings that predated this that changed the calculus. And so considering that, I know this court said that the reason that it didn't consider the pre-filing restrictions to be retroactive was that sanctions could have been requested previously. And even though she did request them and did not prevail, it did not recognize the final orders on those issues to be, or I think it did not recognize that there were final orders. And so it was treated as interlocutory just because there was not something that the court had seen. I think it may have said that I didn't identify the orders that were final. But even if we consider that, the calculus still changes for an award of attorney fees, because the only way she could have requested sanctions previously under the law existing at the time would be within the temporal limits of the request for sanctions. She would have had to follow the safe harbor provisions and all of the related factors. So if she can then file something after the statute, reach back in time and sort of change the factors, that creates a new liability and consequence for me that is now financial, not a prospective going forward. You'll have to complete this pre-filing restriction. And then I think the other aspects of awards of fees, I know I've cited more in detail in my brief, but whether the fees are under Rule 11 or under other family court provisions, awards of fees require that the court consider the ability of the party to pay and the needs of the other party. And that is something that I disputed with the lower court when initially I submitted my financial information and requested an evaluation of the ability of the parties or the needs of the parties. The court said that it was not necessary under this statute. And I asked the court to reconsider, pointing to whether it looked under the family court provisions or the Rule 11 provisions. Both required the same calculation, as did all the precedent of this court. And it would not be logical for a family court provision that is sort of straddling both of those things, Rule 11 and family court procedures, to somehow not require what both of the others did. And the court didn't agree. And so that's, of course, something I'm bringing to this court because there is no precedent on this new statute. The question being, are the needs of the parties still a requirement the same way they would be in either of the other two provisions, since it's just not specified in the statute or precedent?
There was a statement of income, expenses, and assets that the trial judge cites in her opinion. I assume that you filed?
Yes, yeah,
Right.
yeah. And one of my points was that the requirement is the needs of both parties is among the necessary factors, that even if it didn't think that my my statement satisfied the requirements on its own. My recollection is that it specifically said that the two things that I cited from family court and Rule 11 don't apply to this statute, which is really the central issue that I'm talking about here, is that if one party is making 3 times what the other party is making, and the party who's making less and who has to pay does not have the expendable income to pay that cost, then, I think that falls into one of the considerations of Rule 11, as I understand it, and the family court equivalent for awards of attorney fees.
So the logical extension of that argument is if a person has no ability to pay, then they can't be subject to a financial sanction. Is that right?
Well, yeah, and I think they're also, at least my understanding of the way that Rule 11 and the family court equivalent has been applied, is that it's also true that if, let's say for the purpose of argument, one party's making, say, $80,000 and the other party is making $800,000, there still comes the question of like relative need and whether or not it's appropriate for someone to be pushed so far to their limit.
I'm sorry.
Oh, sorry. Well, I might be misunderstanding that, because in a lot of those cases, it's sort of, they're just not showing you sort of like the math and how it all works out. But just generally speaking, that's the expectation, as I understand it.
Doesn't that give a person who lacks financial means the ability to file abusive pleadings without consequence?
Oh, well, I don't think that's the point. I think the distinction is that it's the same as with Rule 11 and other procedures, is that, the point of Rule 11 or the family court equivalent of awarding attorney fees is to deter frivolous filings. But I think it's also important to consider how differently this statute has been applied. So I'll give one example. When I filed an objection to their request for an order restricting abusive litigation, and then a motion to dismiss and a motion for sanctions, those are filed independently as independent requests. And I understand that sometimes it's necessary to file requests independently, in particular with the compliance with Rule 11. I couldn't have filed my request for sanctions concurrently with the other motion to dismiss. But it was considered abusive, not because of the content, but because it was substantially similar to a motion to dismiss. So if we look at the reasoning there, that may open the door to considering whether or not something's abusive, and may open the door to pre-filing restrictions, but that's very different than subjecting someone to a significant financial cost because court rules required 2 filings to be submitted independently, and that action then causes it to be considered substantially similar and therefore abusive. And if you look at the 10/25/24 decision, what you'll see is that was one of the reasons that it was considered that post-statute action justified it, was that motion for sanctions specifically was considered duplicative. And from my perspective, if that's true, then there are things that are considered abusive for the purposes of creating those pre-filing restrictions that are also required under court rules. So it makes it hard to parse out, but I think that's also why it's different whether or not you're making a financial award versus having like a pre-filing screening. They're just, to me, they're very different consequences with very different sort of levels to which I think they need to be judged, especially if a party can't afford to pay. But I think that also leads into a third issue, which is when you're talking about family court, as I see it over and over throughout all of those cases, they're talking about how the child's needs are paramount, and that the point of family court proceedings involving a child are to put the child's needs first, and the equity between the parties is not the goal. I think what Cabot said was something along the lines of the child's interest is the focus, not equity between the parties, something of that nature. And with that in mind, if a award of this nature puts one party in a financial position that is contrary to the child's interest and interferes with child support determinations and things of that nature, I think it creates a new consideration that I think sort of is also in line with the others, which is the needs of the parties are really important, and that I think if a filing can be considered abusive just because it bears resemblance to other filings, and again, using the example of the motion for sanctions, and also putting it into perspective, when I filed the motion for sanctions and the motion to dismiss, the pending filing was their motion for an order restricting abusive litigation. And what it was actually asking is to dismiss, among other things, my motion to enforce production of Exhibit 13, on which I prevailed. So if we consider what I was asking is the court to dismiss a request to dismiss my valid filing, and to file and requesting sanctions for an attorney asking the court to dismiss a valid filing because ambiguously something in the record is duplicative without identifying things by statutory terms, I don't think that's an unreasonable request on my part to say that what he has asked goes too far. The calculus changed, though, once I prevailed on that issue, and by the time of the hearing.
Mr. Dasler, your light is on. If you'd finish your thought, please.
Oh, sure. But it changed once I prevailed on that filing, and the things that were remaining were basically talking about there just being too many filings broadly.
Thank you very much. Your time has expired. Please call the conclusion of the hearing.
That concludes today's hearings.
Thank you.